So Judge McAfee's ruling basically is only one potential liar, and that's what he calls them. He said the odor of mendacity can prosecute a case. You can't have two. You can have one, but not two. And the one can be the district attorney who started all this, who you would think would be responsible. Let's go to Bob, who's calling on line one. Bob, go ahead.
Since we know the proper signification of this word mendacity would be a disposition to lie or habitual lying, right. If Fani Willis decides to continue a case that has the odor of mendacity, could the judge please explain how the continuation with her would not multiply that?
Let me say something, and I agree with you 100%, Bob. I'm going to let Harry comment on this, but I'm going to say something very direct here. This judge is way over his head, okay? He's been out of law school probably 8 or 10 years. This was just on the bench new, and you made a big mistake. And I know he's supposedly conservative, and I get all that. But you can't say the person's lying under oath and has an odor of mendacity in the case, and what she said at the church was legally improper, and then say you could still prosecute the former president of the United States. Judge, what were you thinking? You're thinking about your election coming up, I'm afraid. That's the reality. Harry?
Well, I think you're absolutely correct. So first, there is an odor of mendacity. Secondly, what Fani Willis said at the church was legally improper. But third, you don't even have to go that far in order to disqualify. So the judge on page 13 quotes Federalist number 78. Thus, it is sometimes the case that an attorney guiltless in any actual sense nevertheless is required to stand aside for the sake of what? Public confidence in the probity of the administration of justice. This is a clear-cut case that applies to that particular rule. So the judge had several bases for disqualifying Fani Willis, but could not find any sufficient basis to disqualify her and the fruit of the poisonous tree in this particular case. So instead, the judge says the case against the defendants can indeed proceed. All that Fani Willis has to do is to make a choice, either disqualify herself or disqualify Wade. The choice was actually up to the judge, not to Fani Willis.
Andy?
Yeah, I mean, what Harry said, I was nodding my head in agreement vigorously. The choice is the judge's. The decision is the judge's. The ruling is to be made by the judge. You've abrogated your responsibility as a superior court judge, and you have said, I don't have the courage to rule on this thing the way I need to because I'm running for re-election in Fulton County, and it's heavily Democratic, and I'm a young white Republican judge, so I'm scared. So what I'm going to do is I'm going to say, here, Fani, you decide. You want to stay in the case? Fine, wonderful. Stay in your whole office. 150 strong lawyers can prosecute the president and the former mayor of New York and the former Speaker of the House or the majority leader of the House and everybody else. We only just get rid of your boyfriend, that's all. And that will remove the odor of mendacity. What about your own odor of mendacity? Does that leave too, Fani? No, it stays with you. So basically, it stays with you throughout the case.
So the judge made a huge mistake here. Evelyn's calling from Texas on line 6. Evelyn, go ahead. You're on the air.
Hi, yes. Thank you for what you guys do, and I watch you daily.
Great.
The odor of mendacity says that it stinks, but the judge is not willing to do anything to clear out the stink. It's just going to stay stinky.
Well, exactly. I mean, and even Ellie Honig from CNN, this is bite number 24.
Any one of these statements by a judge would be a career ender. For a normal prosecutor to have an on-the-record finding that there are reasonable questions about whether you lied under oath, that would be devastating. And we'll see what the political effects will be. The bottom line, the DA survives, but not without serious bruising.
Serious bruising is not enough here. She needed to be removed from the case for what she did. Period. Let's go to Sandra, who's calling from North Carolina. Hi, Sandra.
Can't they appeal this, and can't Kemp, as the governor, that he sees there's corruption here, can he not fire her?
Okay, so those are good questions. I'm going to let Andy answer them, who knows more of the Georgia law. Let's start with the appeal. It's a discretionary appeal. It's not a mandatory grant.
Right, because this is a ruling during the pendency of the case, and it's not a final ruling, Sandra. There is no absolute right to an appeal. The judge could say, I'll let you take an appeal, but then you'd go to the Court of Appeals, and even the Court of Appeals has discretion to hear the appeal or not. So the likelihood is, in my opinion, that the three-judge panel of the Georgia Court of Appeals, if it went to them, would probably not hear the case. Secondly, the governor cannot remove her because she has not been disqualified by a Superior Court judge. The governor doesn't have. The governor in Georgia is the source from which all manna floweth, but not that much.
So no to that. I mean, she will be there's no doubt in my mind that she will stay on the case, and she's going to fire Wade. And basically, Wade becomes the fall person on this. I do need to say this. This is why the fight for justice is something you got to keep going, and you got to keep fighting. And that's whether it's in the U.S. Supreme Court, where we fought for your right to vote for the candidate of your choice on ballots across the country. Started out in Colorado. A month later, we were dealing with 15 cases. We won that 9-0. The second part of that case is at the Supreme Court right now. Order probably coming out this afternoon or tomorrow, or Monday. That's why we're filing a brief in the immunity case, because presidents have to have limited presidential immunity for official acts, or they're not going to be able to make decisions. That's why we're defending whistleblowers. So all of this work that goes on is to defend the constitutional republic that we want to leave to our children and to our grandchildren. And you think about that when this decision, the disappointing part to me in the decision was the judge making findings of fact of lying and impropriety and the appearance of impropriety, and then does nothing. And says, well, Fani, you'd make the decision. You could stay in if you want, and you get to try the case, or you can get rid of Wade, and you make the call. And then he said what she said was improper. Legally improper, which, by the way, that's not even a legal standard. Legally improper. You mean unlawful? A violation of the law? This is where this judge is young and inexperienced. But I could say that because I've been doing this for 44 years. But I will tell you, very poorly written decision, wrong conclusion. If he would have said, listen, I listened to the evidence and I didn't find that there was an appearance of impropriety and I don't think anybody was lying, that would be his call. He was the trier of fact. But he doesn't. He says, no, all these things were wrong. All these things were the odor of mendacity surrounding the case. She made statements that were still legally improper, but I'm letting her stay in there. And warning her, be careful, you better not do it again. So all of that takes place. That's why we're engaged in these cases. I know it's frustrating, folks, but that's why you got to have tenacity to stand through that, and that's why we are fighting back.